Next, NTD's Arleen Richards brings us a review of some memorable Supreme Court cases and decisions during the past year and a preview of what to expect in 2026. Take a look.
As we look back at the Supreme Court's docket in 2025, there have been a number of cases that took center stage in the news this year. The court issued around 67 opinions in the 2024 to 2025 term, which ended in June. And before they left for the summer, the justices granted review of 32 cases, with 2 more added on since they returned in October. In addition, the court issued 20 decisions from its emergency docket during the summer. Several hot-button issues addressed this year include transgender rights, presidential authority, and the First Amendment. On the merits docket, in which the rulings are final and the issues will not go back to any lower courts, a case that stands out addressed judicial authority. CASA versus Trump involves an executive order on birthright citizenship, which eliminates a years-long practice of giving automatic citizenship to babies born in the U.S. But the issue presented to the court was whether federal judges had the authority to universally restrict the president's executive orders. The Supreme Court said federal judges only had the authority to provide remedies that are tailored specifically to the parties involved in the case, which means the solution would not apply to individuals or entities that had not filed a claim. President Trump applauded the decision.
But in recent months, we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for.
So what does that mean for the cases that challenge executive orders? An attorney explained to ABC News.
You're going to see more lawsuits filed and more lawsuits with class action allegations, because no more can you find one judge in one obscure county to issue a nationwide injunction. Instead, you're going to have to ask a judge to certify a class and follow those procedural rules, which are cumbersome.
The justices left open some narrow pathways to universal restrictions where no other remedies would work. Another hot-button issue this year, transgender rights. The justices heard a few cases on this topic, but a case that stands out is United States versus Skermetti. The court ruled that a Tennessee law prohibiting medical professionals from providing gender transition drugs to minors was legal. An ACLU attorney who challenged the law said it violated the 14th Amendment.
We think it's quite obvious that the law does classify based on sex, and that the court in this case had to do a lot of backflips to get around the logic that they use, that the law doesn't classify based on sex.
The Skermetti ruling didn't settle broader questions about transgender rights or other state bans. The court is expected to address more transgender rights issues in that case, as well as in others, including a case about transgender students participating in girls' sports. In Alabama, parents sued a public school for the right to opt their children out of instruction that uses LGBTQ inclusive storybooks. The school board had ended its opt-out policy when it received numerous requests. Oral argument in this case lasted 2.5 hours, with Justice Brett Kavanaugh at one point saying to the school's attorney, "This is a tough case to argue."
And I guess I'm just not understanding. The whole goal, I think, of some of our religion precedents is to look for the win-win, to look for the situation where you can respect the religious beliefs and accommodate the religious beliefs while the state or city or whatever it may be can pursue its goals.
Other significant First Amendment cases before the court involved commercial websites publishing sexually explicit content and the eligibility of religious charter schools to receive state funds. Another avenue for relief is through the shadow docket. The court makes decisions on these matters outside of the regular case docket, such as over the summer during their recess. The Trump administration submitted several emergency applications during the recess, many involving appeals of lower court rulings that block significant executive orders. The Supreme Court's orders on this docket have largely been in favor of the administration. For example, the court allowed for the administration's global tariffs to temporarily remain in place while the case waits for a final decision. In November, they heard arguments on whether the president overstepped his authority when he imposed sweeping tariffs on foreign nations. Several justices were skeptical of arguments on both sides. What could the remedy be if the government loses? Justice Amy Coney Barrett said the reimbursement process could be a mess. The final decision on this case is likely to be a close call. But the court hasn't always ruled in Trump's favor. Just recently, the majority denied the administration's request to keep deployed National Guardsmen in Illinois. They ruled that the administration must first use the military to enforce federal law. Next year, the court will decide several cases that could expand or stifle the president's power, making it one of the most significant terms in decades. Arleen Richards, NTD News.